In North Carolina, custody comes down to one standard, not who earns more, not who filed first, not whether you're the mom or the dad. One standard. Whatever arrangement will best promote the interest and welfare of your child. Here's what that actually means for your family. North Carolina custody has two parts, and getting them straight will save you a lot of confusion. Legal custody is decision-making authority, education, medical care, religious upbringing, the big choices. Physical custody is where your child actually lives day to day. Each one can be sole, held by one parent, or joint, shared between you, and the two don't have to match. It's very common for parents to share joint legal custody. Both have a say in the big decisions, while one parent has primary physical custody and the other has a regular schedule of time. One more piece of vocabulary. What most people call visitation is really just a smaller share of physical custody. A parent with visitation is still a parent with court-protected time. Here's the part that surprises newly separated parents. If you are both legal parents and there is no custody order and no signed agreement, you each have equal rights to your child. Neither of you has custody in any enforceable sense, which means practically neither of you is violating anything by keeping the child, and neither of you can make the other return the child without going to court. That's why getting something in writing early matters. An informal schedule that works today can fall apart the moment one parent decides not to honor it. Until there's an order or an agreement, there's nothing to enforce. The controlling standard is the best interest of the child. There is no checklist in the statute, which means the judge has broad discretion to weigh everything that bears on your child's well-being. Two things the statute addresses head-on. The judge must consider any acts of domestic violence between the parties and the safety of the child, and the judge may not favor either parent based on their sex. Because that standard is so discretionary, appellate courts rarely reverse a custody decision. The trial judge who saw and heard the witnesses gets enormous deference, which is exactly why experienced custody lawyers push hard to settle. A negotiated arrangement keeps the decision in your hands instead of handing your family's future to a stranger in a robe, however well-intentioned. No, North Carolina abolished the old tender years doctrine decades ago. The statute is explicit. Between two parents, no presumption applies as to who will better promote the child's welfare. In real courtrooms, the parent who has been the primary caregiver often does have an advantage, not because of their sex, but because continuity of care is powerful best interest evidence. A father who has been the hands-on parent walks in with exactly the same advantage. What matters is the caretaking record, not the label. And can your child choose? Not exactly. There's no age in North Carolina at which a child picks. A judge may consider the preference of a child mature enough to have a reasoned opinion, usually through a private conversation in chambers, not testimony in front of both parents. And even then, it's one factor, never the deciding vote. If custody or visitation is contested in court, North Carolina requires your case to be set for mediation before it can be tried. Every judicial district runs a custody mediation program through the court system, and for most families, those sessions come at no charge. Mediation is a structured conversation with a trained neutral whose only job is to help the two of you build a parenting arrangement through schedules, holidays, decision-making exchanges. What's said there is confidential and can't be used against you later, which frees parents to talk honestly. Reach an agreement, and it's written up as a parenting agreement. Signed by a judge, it becomes a court order. The court can waive mediation for good cause, including allegations of domestic violence, abuse or neglect, substance abuse, undue hardship, or when a party lives more than 50 miles from the court. If there's a protective order or a history of violence in your case, tell your attorney immediately. You should not be forced to negotiate across a table from someone you fear. There are three ways custody gets settled: a parenting or separation agreement, a consent order signed by a judge, or an order entered by a judge after a hearing. And here's the distinction that trips people up. An agreement that stays a private contract is enforced and changed differently than a court order. If your custody terms live only in an unincorporated separation agreement, they're a contract. A violation is a breach of contract where there's no contempt power behind it. And if either parent later files a custody action, the judge isn't bound by your agreement. The court decides fresh without anyone having to prove circumstances changed. If your terms are in a court order, violations are punishable by contempt, and changing them requires the court to find a substantial change in circumstances. Neither structure is automatically better. It depends on how much flexibility versus enforceability your family needs. And it's exactly the kind of decision worth an hour with a lawyer before you sign anything. To change a custody order, you have to show a substantial change in circumstances affecting the child's welfare, and that the change you're asking for serves the child's best interests. The change doesn't have to be a bad one. A move, a new work schedule, a child's evolving needs can all qualify. But it has to genuinely affect the child, not just the parents. And if the other parent violates the order, a parent who knowingly and willfully violates a custody order can be held in contempt. Consequences that run from makeup time and attorney's fees to, in serious repeat cases, jail. 2 rules while it's happening. Document everything: dates, times, texts, missed exchanges. Contempt cases are won on records, not recollections, and don't self-help. Custody and child support are independent obligations. You cannot withhold the children because support is unpaid, and the other parent cannot withhold support because they're unhappy with the schedule. Courts come down hard on both. Custody is the part of family law where the stakes feel and are the highest. Here's the good news hiding in all of that. Parents who prepare well, document well, and stay focused on their children resolve most cases without ever going to trial on terms they helped write. At McCrary PAC, we've guided families across Iredell, Catawba, Alexander, Caldwell, and Burke counties through every path on this map, from kitchen table parenting agreements to hard-fought trials, where clients are neighbors, not numbers. The full guide this video is based on is linked below. Reach out today, and let's talk about your kids.